I've been told I need to be really, really bossy, which, being a lawyer, that comes very easily to me. So just by way of introduction to this session, I don't know about the rest of you, but I often find myself somewhat baffled by an apparent paradox on our campuses, in that they are more diverse than ever. Our student body has grown up with some of the most extensive, though not necessarily perfect, law and policy and social consensus around equality and inclusion that we've ever seen. And yet we're seeing, in some respects, more and more unacceptable behaviour. For example, the Equality and Human Rights Commission report published a couple of weeks ago on the scale of racial harassment on university campuses was, I think, for all of us who are involved in universities, both a sobering and a challenging read. So we are all too aware of the impact that incidents of hate and harassment can have on the lives of individual students, on the wider university community, and on the time, resources that such events can take to address after the event. So really developing an effective, proportionate and realistic institutional and indeed sectoral response is something we all need to work towards. So the aim of today's panel discussion is to look at what the role and responsibilities of institutions are, what an effective response might look like, and what the leadership and governance commitment should be. We have an excellent panel to provoke our collective thinking, and I will introduce them all in a few moments. But perhaps we could start with our keynote speaker, Dr. Ann Olivarius.
Thank you, everyone, for having me. I must apologize. I'm one of those people who was blessed, I guess at birth, with incredible stamina and great health. And about 16, 17 days ago, I started a business trip. I've just come back, and I feel more like a zombie than I do a human being. And I begin to understand when people say, just give me the morphine and let me die. I'm feeling a little bit more like that. So I'm trying to bring you my best, but I apologize if I start to cough or if somehow I am off the mark a bit today. It's not for any intention, I can assure you. The topic is a near and dear one to me, and I'll give you the best that I can give you of me today. So I want to talk about, I'm a lawyer, and I want to talk about who I am, because I think when you hear topics about sexual harassment or any speaker, you wonder, who are these people? Why will I really want to hear from them? So I'm one of the architects of sexual harassment law. I brought the first case in the United States, Alexander v. Yale, with Catherine McKinnon and a number of others. We formulated the legal theory, and we were able to get a Connecticut court to say, right, that's a legal theory that makes a lot of sense, and actually sexual harassment violates the law in the United States, and that got the ball rolling, and that was way back in 1978. So today, what do? I'm a lawyer. I run McAllister Olivarius, which is an international law firm. We're headquartered here in London, but we also have offices in the United States. And we handle all sorts of stuff, but we do an awful lot of what I'm going to call women's law, because it has evolved that way. I started off doing mergers and acquisitions for Goldman Sachs and Morgan Stanley. And then after I did that sort of quant stuff, it seemed to me that I would practice law, but I knew as a woman I wanted to have the best credentials I could have. So I went to Yale, was at the top of the class at Yale, and then I went and was a Rhodes Scholar at Oxford. And having accumulated the degrees to make one somewhat impenetrable from criticism when one's going to fight a tough fight, I've embarked on that. So Mandela was kind enough to introduce me as someone who's helped change the world for the underdog. And it was a great honor, but to have a chance to work with him. So my life has been dedicated on social change. What can we do, and how can we be most effective doing it? Right now in Britain, I'm one of those people who help put the revenge porn law on the books. In this country, as you may know, if you've had pictures, naked pictures of yourself sent, and you don't want that to have happened, then you can do something about it. And if it was done for fun, you can't do anything about it. It was just a good time with the mates. There's no law that can protect you. If somebody did it for money, to earn some money, we can't protect you either. But if they did it because they wanted to hurt you, to cause malice, then certainly we can put you in jail. And we've got over 3,000 people in jail in this country for sending around revenge pornography or non-consensual pornography, whatever you call it. And I will say that it's not just a gendered crime, although it's a highly gendered crime, but we have many hundreds of women in jail who also feel that they like to get even with people and hurt people and send pictures around. So it's not just you guys are the bad actors. You're not. This came about because of the Christy Chambers case, a case of a woman who came to us. She's an American woman who had a British lover. They broke up on the last night they were together. Unknown to her, she became paralytic drunk. He then raped her and filmed her in the rape. And then after some years, when she became a lesbian and very famous, she runs a YouTube channel with her now wife, Bria Cam, and they've got millions and millions of viewers. They're making a whole bunch of money, mostly dealing with the teenage crowd, videos they put out on how to buy your first bra, la la, la la, and stuff like that. And they're really effective at what they do, have a great following. So he was very angry and sent around the pictures of this rape of her. We went to the Met Police, and the Met Police said they wouldn't do anything about it. And when I said why, the Met Police said, well, for two reasons. One, there was a dildo in her hand. She's paralytic drunk. He had placed it in her hand. She wasn't doing anything. And I said, okay, what's the other reason? I don't think that one really works. The other reason was even better, I'd say, because he said she was shaved, her pubic hair was shaved, and so it indicated to them on the Met that she was interested in having sex. And so that's what we started. That was just 3 or so years ago. That was the response we were getting from the Metropolitan Police, and that produced the energy to put a revenge porn law on the book. We then organized last year, we handled the Rubin divorce case in California. He's the creator of some of those phones and considered a great technologist. And he enforced a woman working for him at Google to give him oral sex on the job. And then when Google found out about it, they had to fire him because actually this one was a little bit too far. So they said, okay, we'll get rid of you, but they gave him $90 million to leave. And so we organized a walkout around the world. You may have heard of it. 20,000 people from Google walked out to say, that's really not good to do. We're suing Mount Sinai Hospital to make the world better for patients there and safer. We have a high amount, now almost 200 high-impact cases around the world, similar to the ones I've just told you. So my business model, and for those of you educating the next generation, my business model is do good and earn a lot of money at the same time. So you don't have to go work, but kids come up all the time and they say, what am I going to do? And I went to Yale Law School, and a third of the class did not-for-profit work and never made any money and perhaps had good lives, but not necessarily because you do not-for-profit work. And then another third, more than that, went off and really went to Wall Street, magic circle firms, and uniformly they say, what have I done with my life? I've made a lot of money, but what have I really done? I think you can work for good causes and people, you can earn good money, and that can be a real enticement for people. So I really encourage that because I think a lot of kids can think they've got to go work for actors that are not contributing positively to the social environment. So I'm here today to talk about social change, specifically with regards to the UK, and comparing it to the United States, where 42 years ago, Title IX was passed. It said in 1972, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That was thrown in during President Johnson's term. Nobody thought he was a great civil rights person at the time, but what so often happens with history after the fact, he's a lot better and much more progressive than those who have come. I rest my case with Donald Trump, who has been pushing back on everything. This law, actually, if there was one law, as a lawyer, people said, what law made any difference for women? You could say suffrage made a big difference. But I'd say this law has changed the whole universe for women in the United States. Because for a whole generation of women, my generation, we had access finally to the great educational institutions. Everything was being knocked down. The male-only signs were being knocked down, and women were being included. When I went to Yale, women who hadn't gone to Yale beforehand, we all felt blessed, and our job was to pay it forward, to somehow give it to others. But Title IX meant that we were actually entitled to use our bodies. We could have sports on the same basis that the men had. So when I went to Yale, it was extraordinary. There were all these male sports, and all these old blues that would come and watch them. And for the women, two little things, the theory being that women really aren't athletes, they really don't want to do it. It's changed so much now that I think that my law firm soon will be bringing cases around the world, but certainly in the United States, saying that there should not be any sex segregation in sport. Why should there be girls' teams, boys' teams? If you're a big woman and you've got the oomph and the muscles to play football, then compete. If you can pass the line, whatever it is, you should be able to compete. What difference if you're a good tennis player? Why do you have to be on a boys' team or a girls' team or a men's team or a women's team? That's where the thinking is going, which I know is not being talked about much here, but certainly in the States now there's beginning conversations. We're going to bring those cases forward because there's no reason to have sex segregation when one thinks about it. It may be a little bit unusual at first thought, just like it was really unusual for a girl to go to on a Rhodes Scholarship like I got, or for a girl to work and do all the stuff that I've done. The world has changed. The world's continuing to change. So under Title IX, in 1973, I was at Yale. That's me. And the place was a fabulously exhilarating intellectual place. The head of the university, Kingman Brewster, who said his goal was always to produce 1,000 male leaders a year. When they took women, he just added the women on. We were the extra bit. And so the dorms became really crowded. The place became more profitable. There was a lot more money because obviously more people paying tuition. And we pay real tuition, not like you folks pay here. We're paying huge amounts of money to send our kids. And any American who gets a kid into Harvard, Yale, Princeton, you'll sell your house, you'll do anything to get your kid through that educational institution. It's a very different mentality when it comes to that. So the women were just the extras. They had, when I was at Yale, Dr. Phil and Lorna Sorrell were a married couple. He was an obstetrician gynecologist trained at Yale. They ran an article in Cosmopolitan magazine and a lot of the really sexy magazines at the time on sexual health. These were all new days, all new topics. And I saw them recently, and they said to me that they had 223 women in the class of 1973, the first entry class at Yale. Of that, 214 of those women came to see the Sorrells. So 214 women said, something is so wrong that I'm going to see a mental health person. And this is still not in the days when therapy is considered common fare. For most people, it was still like, whoa, whoa, be careful, be careful. But somehow 214 of the entry-level girls went to see the Sorrells. They then did a questionnaire, gave it to 30,000 Yale students and a few others. I'm sorry. When they looked at it, about the questionnaires, the only thing they required of everybody who came over this decade was answer one question amongst others. But the one question that went through the decade was, tell us about your first sexual intercourse. What was it like? When I saw Phil Sorrell, Dr. Sorrell, this summer, he said they'd recently gone through everything that they had collected. They had volumes and volumes, 30,000 responses. And he said almost every single response was a response that suggested it was unpleasant, perhaps coerced. He said, we read it through now and we think most of these women were in situations, remember it's a high post-60s, early 70s, a lot of sexual freedom just around Roe v. Wade and abortion rights. Birth control is finally available. And he said, it was his view, he said, as an octogenarian and a doctor who's seen it all, that almost all these women had been raped. And he said, but nobody looked at it that way. Nobody thought in those terms. Nobody talked about what is consent and how does a woman feel forced into having sexual relations. So in my senior year, the Yale Corporation, which is the governing body, asked me to do a report on the status of women at the institution since the beginning of coeducation. So I went around and thought I'd do a humorous report at first, but after a while I started getting reports from a lot of students that they were having sexual relations with professors. And in fact, we had so many reports of this. We started then getting reports of women who actually said, well, I've been raped by this person, that person. There's a professor, Keith Bryan, who taught flute, and we found out that he had been discharged from his American high school in New Jersey for allegedly raping 2 minors. He then went to Yale. So we got this report together with a lot of these reports, and Yale said, wow, well, we don't really want to know about this. They actually still don't really want to know about it. It's a very common problem. We had nothing else we could finally do to change the system because we went to the administration and said, we'd just like to have a central reporting mechanism because Yale, like Oxford College, for instance, has got residential colleges. So there are 12, now 14 residential colleges. So if you had a rape in one college, it wouldn't be reported in a central database. So this could be happening numerous times. You could have a serial sexual predator and not know it. And Yale had quite a few faculty who were serial sexual predators. I say quite a few, I'd say in the dozen range that we found out about, which I think is a lot. So we asked for a central reporting system. Yale said no, they didn't want to do it. And then they said that Keith Bryan was going to have me arrested for defamation for having organized this report. I had not gone to law school. I didn't realize you couldn't go to jail for defamation. I was just about to graduate. And we decided then that we had to do something. So I met with Catherine McKinnon and said, I think we have this kind of behavior, which we've isolated. We have witness statements. I think we can call that sexual harassment. And I think we should file suit. And I'll organize the evidence. And we did. And as I said, Yale played the game along so that we all graduated. Once you graduated, you no longer had standing to bring that lawsuit. So it became moot, but the court did find in Connecticut that sexual harassment behavior, if the university wasn't doing something to stop it, it was in violation of law. I will say also, just because you're with the universities, for me it was a really coming-of-age moment. I was at the top of my class at Yale, and Yale's public relations office, which was growing pretty strongly at the time, went around and said that the plaintiffs in the lawsuit were all terrible human beings. I had never quite encountered that. I really believed in Yale and higher education. I still do. All my kids have gone there. It's a fabulous school. But they went around and they said, well, Ann is failing out. Well, I got a Rhodes Scholarship, a Marshall Scholarship. I got into Harvard and Yale Law School. I don't think anybody at that time had ever done that. And then they said also that I was a lesbian. That's interesting. They didn't say it as a compliment, I can tell you. It was absolutely meant to be something to put me out of business. I, at the time, was living with the guy who's still my husband, but that made no difference. So to see how a university actually doesn't necessarily tell the truth is very interesting and painful to behold. Now, we find that we're getting telephone calls, I would say off the hook every week, 5 to 7 calls from students in British universities who call us and complain of sexual harassment, rape, assault, all those things. We know the statistics are 1 in 3. I think there have been 9 studies I've seen done in Britain on sexual assault. They vary. There is one that says 1 in 4, one that says 1 in 5. Almost everybody says 1 in 3. Regardless of it's 1 in 4, 5, 3, 7, I don't care. It's an epidemic. And I think it's time that university administrators said, we have a roaring problem. What are we going to do about this problem? So Title IX is one answer. In the States, the standard is, for a university, it's much tougher than here. There's 2 standards. One, the university had to be deliberately indifferent and not do anything when it was told to them that there's a case of rape, assault, sexual harassment, for them to be at all liable. And depending on where you are in the United States, and whether you have a Trump judge or perhaps an Obama judge, you may get very different outcomes. So that the other thing that you can have in the States, though, now it's very important that when you hire faculty, you have to do your due diligence. And if, like Keith Bryan, had been accused of rape at the high school level and you hire him, and then there's an accusation at your institution, you're going down. That's not going to work. Now they want people in the United States, even if a student's been accused, there's been an investigation, it goes in his or her transcript, so it follows you through life. Professors have been accused, it's in their transcripts. It's in their personnel files, it has to be. So they're getting really tough about it, and it's made a huge difference. And in fact, just this year, I was working with the National Academy of Sciences, National Institutes of Health, which fund almost all science in the US. And they've now agreed that if an institution has got credible allegations and they've been found to be in violation of Title IX, of sexual harassment, if you've got sexual predators, you're going to be denied your federal funding, which is going to put educational institutions out of business. So now we're escalating it up so that you have to address this problem. I have to address this. 1 second. The Equality Act itself here is underutilized. In the UK, though, it's a much higher standard because it's assumed that if somebody misconducts themselves and they're found guilty, that the institution is vicariously liable. So you've got a much higher standard in some respects. Although it's very clear that the law has not actually gone through the court systems, we've gotten dozens and dozens of settlements with universities for vicarious liability under the Equality Act, but we actually haven't had to take it. Nobody's had us actually bring it to court, to the tribunals. So that's still coming. It's not there. So just to wind up, the problems with the UK university sexual misconduct hearings, complainants are often denied access in this country to representation, so they go in cold, they don't know what they're doing, they're not advised of the systems, they're not advised how to handle them properly and navigate them, they don't have any representation or people to guide them, they're not shown the evidence often, they're not allowed to comment on the evidence, they're not treated as a party to the investigation, things take a lot of time, they're not handled quickly, which is wrong, and then in many cases, complainants say they're not allowed even to attend their own hearings. So there's significant limitations both with Title IX and with the Equality Act, but I think here the Equality Act, thanks to Me Too and a lot of hard work, things are really taking off. Universities are being brought to task in a different way. Last year, Oxford University said to me, no, the chancellor said there's no sexual harassment, we don't have that problem. Well, I think I probably have 62 cases in Oxford of sexual harassment, alleged assault, rape. Cambridge is much further ahead. We've been working with them for some time. A lot of other universities now come, and we work with them to get practices in place. So what can you do? I say to you, if you're a great organization, you come together, you care about these issues, they mean a lot. You want to put Britain on the map as being the best actor, I'm sure, in the world on this. So what you need are really clear regulations, rules. What's a violation? What's not a violation? If a student has been harmed or an employee, what can they do? What options do they have? Where do they go? How do they solve that problem? If you're students, you have to file your complaints and go through the system, and then the universities have to actually enforce the regulations. So that's it, folks. Thank you.